In this video, we look at the nature of contracts. This is really an overview of what contracts mean. This course is going to involve a great deal of focus on contracts, so I thought it might be best to review what you learned in the first business law class and talk about what contracts are. And essentially, contracts are enforceable promises. That means there's two aspects to any contract. First of all, there's an exchange of promises. I promise to sell you my computer for $1,000. You promise to purchase my computer for $1,000. So I promise to sell, you promise to pay. That's an exchange of promises. But the law does not enforce every exchange of promises. Enforceability is a sort of radical concept when you think about it. What enforceability means is that in our private affair, in our private business dealings, if in fact you don't pay me the $1,000 for my computer, and we have a valid contract under the law, meaning it meets the elements of a valid contract, that means that I can go to the state of Oklahoma using the court system and sue you and ask the state of Oklahoma to force you to make good on that promise that you made me. So if in fact you don't pay me the $1,000, I can eventually, assuming I win at court and win at trial and win at appeal, I can then ask the county sheriff to go to your house and take goods that are worth $1,000, sell them, and give me the money. So that's sort of an amazing idea, right? That enforceability allows the state to intervene in our private affair. And that's what makes contracts so unique. Now, contract principles facilitate commerce. Our whole economic system, our social system as well, is built on a foundation of contracts. Contracts are so important that even the United States Constitution references contracts. In the Constitution, remember, the framers of the Constitution were very concerned that people are treated equally in the different states. And so one of the provisions of the Constitution is that every state must respect the contracts of every other state. So respect for the idea of contracts is built into our social and economic system. Finally, contract law is primarily state law. There's very little federal law of contract, meaning contracts are going to be construed according to Texas law or Oklahoma law or Delaware law. Contract law is a function of state law. So in this segment, in this video, we're going to look at the basic definition and purpose of a contract. We're going to list the basic elements of a valid contract, and we're going to distinguish various ways that contracts can be classified. Let's start out by talking about the nature and application of contracts. Why do we enter into contracts? Well, contracts allow businesses to protect expectations and manage their risks. We open this course by talking about the expectations and risks involved in any commercial business transaction. And we manage those risks and we satisfy those expectations through the use of the contract. Now, every contract is premised on the notion that the parties will engage in good faith dealing. That means the parties approach the contract with honesty in fact. So good faith really means that you are acting honestly. Remember, it's not a situation where I'm going to take advantage of the other person. Instead, I must approach every contract in good faith. Now, the elements of a contract, a basic contract, a valid contract, has 4 required elements. There must be mutual assent, and this is often characterized as offer and acceptance. It is agreement. Sometimes we refer to this as a meeting of the minds, a mutual assent to a contract, offer and acceptance. Consideration is the second element of a contract, and consideration is a feature that is sort of unique to the common law. And if you take my international law class, we talk a lot about the differences between the common law and civil law. But essentially what consideration is it means something of value is exchanged for the promise that both sides obtain something of value, which we refer to as a legal benefit, and you give up something of value, a legal detriment. So going back to that initial discussion about selling my computer for $1,000, I am giving up my computer in exchange for something of value, meaning the $1,000. You are giving up your $1,000, but receiving something of value, being the computer. So that's what consideration refers to. And in our common law system, every contract must have offer, acceptance, and consideration. Now, the next consideration is legality. The purpose of the contract must be legal. We are not allowed to contract for illegal purposes. A valid contract requires that there be a legal purpose as the goal of the contract. So I cannot enter into a contract with you to burn my neighbor's house down. That is not a valid contract. Finally, capacity. And when we talk about capacity, we refer to the idea of legal standing. Both parties must have the ability to enter into a contract. So we see this idea of legal standing oftentimes for people who are guardians of someone. Now, contracts may be classified according to their status. The first type of contract, first type of contractual status, is a valid contract. And a valid contract is simply a contract where all of the required elements are present. So it's a contract that includes mutual assent, offer and acceptance, consideration, and is entered into by parties with legal standing and which has a legal purpose. A void contract is an agreement which lacks one of the required elements, at least one of the required elements, of a valid contract. So an agreement that lacks a required element is simply a void agreement, meaning there is no agreement. So if you and I enter into a contract in which I ask you to burn down my neighbor's house, which is an illegal purpose, the contract is void, meaning neither party can enforce that contract. Thus, neither party has any rights or obligations in reference to that contract. Voidable is a little harder to understand. Essentially, what voidable says is that one of the parties may have the right to cancel a contract that would otherwise be valid. So we may have a contract in which it would be an injustice for one party to walk away from their obligations under the contract. You see this in instances, say, where a minor enters into a contract. Say a minor enters into a gym contract. We want to ensure that the party that is required to perform under the contract doesn't get to take advantage of the fact that the other party was not part of the valid contract. Unenforceable contracts is a valid contract that cannot be enforced by the court because of a legal defense. Probably the best known type of contract, unenforceable contract, would be a contract that's barred by the statute of limitations. The statute of limitations is what we call an affirmative defense, and every state has a different time period in which you can bring a claim for a breach of contract. So in the case of a statutory defense of statute of limitations, that means that I have a valid contract, you have breached the contract, but if I have waited longer than the allowed time period, then I'm going to be without the chance of recovery. I cannot bring that case. So it is an otherwise valid contract that is now unenforceable. Now, there's other ways that we can categorize a contract. First of all, by contracting system. Now, we've already talked about common law contracts, which are contracts for things like services or real estate. Employment contracts or rental agreements are always common law contracts. Or it could be UCC contracts. Remember, the UCC governs contracts for the sale of goods, And a good, remember, is a tangible, movable item, an item that it can be separated from land. Real property, real estate, is land and anything permanently attached to the land. We can also classify contracts by level of contractual commitment. There is a bilateral contract, and these are the contracts that we tend to understand. These are an exchange of promises. I promise to sell you my computer for $1,000. You promise to pay me $1,000 for that computer. So that's a bilateral contract. The obligations run in both directions. A unilateral contract is a contract in which one party's legal detriment arises from its action or inaction. So it is not an exchange of a promise for promise, but it's an exchange of a promise for an action. Meaning, if I post a reward offering $1,000 for the return of my lost dog, then you are not promising me anything, but nevertheless, if you return my lost dog, I have a binding obligation to pay you the $1,000. So a unilateral contract. We also can categorize contracts by their level of explicitness. For instance, explicit contracts are express contracts, terms that are defined by the parties either orally or in writing. We have expressly stated what the terms of the contract are and may have all definitions included within the contract, even if it's an oral contract. Now, the statute of frauds requires some contracts to be in writing in order to be enforceable. Businesses generally favor explicit written contracts in order to minimize risk. The more that detail that we can put into a contract, the less risk that we are exposed to. Now, the other type of contract would be an implied contract. And an implied contract, terms are implied by the parties' behavior or through custom, meaning how have the parties acted in terms of this particular agreement, or how have the parties acted in regard to other agreements. So if I have an agreement to sell you vegetables, and I will bring the vegetables, I'll drop them off at your place of business, you'll have a chance to inspect the vegetables, and then at some point you will notify me of what you're going to pay, and then I return to pick it up. Even though we haven't expressly written that agreement down, our actions have led to the level of an implied contract, where the terms are implied by our behaviors. And that's it. So in conclusion, what did we learn today? Contracts allow businesses to protect their expectations and to manage their risks. We know that a valid contract, an enforceable contract, must have certain elements: mutual assent, consideration, it must be for a legal purpose, and the parties must have legal standing. And finally, contracts can be categorized in different ways. As I said, this is a short video. It's not going to be that important in the overall scheme of things, but it's important for you to get an idea of what contracts are all about. Thanks for listening. I will talk to you soon.